If you are an immigrant living in or passing through the United States right now, there is a development unfolding at airports across this country that you absolutely need to be aware of. And more importantly, there are three specific documents that could determine whether you move through that terminal with confidence or find yourself facing a situation you never anticipated. Welcome back to US Updates Hub. We are glad you are here today because what we are about to share with you is not about creating panic. It is about preparation. It is about walking into any airport in America with a clear understanding of what you have in your possession, what your rights are, and how to safeguard yourself and your family. So please stay with us all the way through this video because every part of this content is directly relevant to you. As of April 2026, the reality inside American airports has shifted in significant ways. What many people have not fully grasped is that Immigration and Customs Enforcement, the federal agency commonly known as ICE, has been deployed to dozens of major airports throughout the United States. This is not based on rumors. This is not social media speculation. This has been confirmed through official statements from the Department of Homeland Security and has been covered by established news organizations including Reuters and the Associated Press. The deployment began gaining momentum in March 2026, and as of late March, ICE agents had been confirmed at major travel hubs including Hartsfield-Jackson Atlanta International Airport, both Houston airports, those being George Bush Intercontinental and William P. Hobby, and John F. Kennedy International Airport in New York, among others. And here's the essential context you need to keep in mind. Additional airports are expected to be added to that list going forward. So how did we arrive at this point? The short explanation involves a partial government shutdown that began affecting the Department of Homeland Security in mid-February 2026. That disruption in funding left tens of thousands of TSA officers working without receiving their pay. And according to multiple credible reports, hundreds of those officers have since resigned or stopped reporting for duty, resulting in security lines stretching for hours at major airports across the country. In response, the administration began reassigning hundreds of ICE officers to airports to provide operational support, including managing queues, monitoring exit lanes, and checking passenger identification. And while the official characterization of their role focuses on supporting TSA operations, here is what every immigrant needs to clearly understand. ICE officers do not set aside their immigration enforcement authority when they walk into an airport terminal. Under federal law, specifically 8 USC Section 13-57, ICE officers retain the power to conduct searches, make arrests, and question individuals about their immigration status wherever they are carrying out their duties. That authority does not pause simply because they are also assisting with crowd management. So let me pose a question to you. If an ICE officer walked up to you in an airport today at this very moment, would you know what to present to them? Would your documents be current, valid, and physically on your person? Would you know what the law requires you to carry versus what is simply wise to have? Those are exactly the questions we are addressing today. And our goal is for you to finish this video feeling clear, composed, and thoroughly prepared. Let us discuss the three documents every immigrant should carry. And precision matters here because the correct document depends entirely on your immigration status. And that distinction becomes critically important in an enforcement environment like the one that currently exists. The first document is your primary proof of lawful status. This is your foundational document, the one that establishes your identity and your legal standing in the United States. For lawful permanent residents, commonly known as green card holders, that document is your permanent resident card, officially designated as Form I-551. Federal law under 8 USC Section 4E requires that lawful permanent residents aged 18 and older carry this card on their person at all times. This is not a recommendation. It is a legal obligation, and failing to comply can technically result in a fine of up to $100 and potentially up to 30 days of confinement. In practice, however, the more immediate concern is the possibility of being detained, subjected to extended questioning, and potentially missing your flight while officers work to verify your status through other channels. If your green card has expired, do not assume that is acceptable. An expired card on its own creates a problem. However, if you have submitted Form I-90 to request a renewal and have received a USCIS receipt notice, carry that receipt notice together with your expired card. If you hold a conditional green card and have a pending I-751 petition to remove conditions, carry both the card and the I-751 receipt notice together. For non-immigrant visa holders, and this encompasses a broad and diverse group that includes individuals on H-1B work visas, L-1 intra-company transfer visas, F-1 student visas, O-1 visas for individuals with extraordinary ability, TN visas, E-2 investor visas, B-1 and B-2 visitor visas, and many others, your primary proof of status consists of your valid, unexpired passport combined with your visa stamp. Those two items together form your foundational document set. For individuals who have been granted asylum or refugee status, your primary proof of status is your asylum approval letter or your refugee travel document, depending on the manner in which your protection was granted. For individuals holding temporary protected status, commonly referred to as TPS, or those with deferred action for childhood arrivals, known as DACA, your employment authorization document, or EAD card, serves as a vital proof of status. Immigration attorneys and legal advocacy organizations throughout the country consistently stress that for DACA recipients in particular, carrying proof of that status when traveling is not something to be casual about. It is essential. The second document is your I-94 arrival and departure record. If you are not a United States citizen or lawful permanent resident, the I-94 is one of the most consequential documents in your entire immigration file, and it is one that far too many people neglect to review or forget to keep accessible. The I-94 is the official record maintained by United States Customs and Border Protection that documents when you entered the country, under what immigration classification, and when your authorized period of stay expires. CBP transitioned away from issuing paper I-94 cards at most airports several years ago, which means that for the majority of travelers, the I-94 record exists in electronic form and can be retrieved through the CBP website at i94.cb.dhs.gov. Here is what we strongly encourage you to do right now or immediately after finishing this video. Visit that CBP website and pull up your most recent I-94 record. Look at the class of admission, which indicates the visa category under which you were admitted. Look at the admit until date, which reflects the outer boundary of your authorized stay unless you have received an approved extension or change of status. Print that record, take a screenshot, save it to your phone, and whenever you travel, keep it readily accessible. Immigration attorneys who are advising clients on airport travel in the current environment consistently recommend that non-immigrant visa holders carry their most recent I-94 as a standard part of their travel documentation. The reason is straightforward. If an ICE officer asks about your status, and you are able to present not only your passport and visa stamp, but also a current valid I-94 that confirms your lawful admission and authorized period of stay, you are giving that officer a complete and immediately verifiable picture of your situation, right there in the moment. That can mean the difference between a brief routine interaction and a prolonged secondary screening. For H-1B and L-1 visa holders in particular, having your I-94 accessible also allows you to connect your admission record to your current employer petition, which brings us directly to the third document. The third document is your USCIS approval notice or status-specific supporting paperwork. Let me explain what this means for different categories of travelers. If you hold an H-1B work visa, you should carry your most recent Form I-797 approval notice. That is the official USCIS document that authorizes your employment petition. You should also carry a recent pay stub and a letter from your employer confirming your employment, your position, and your work authorization. The reason this matters is that in the current environment, immigration officers are paying heightened attention to whether a person's stated employment and status are consistent with their official records. Reports from visa-focused outlets and immigration attorneys have noted that USCIS is now conducting more rigorous electronic checks, including reviewing social media for consistency and cross-referencing tax filings and form submissions. If there are discrepancies in your records, for example, if your professional profile online indicates you work for a company that is different from what appears on your I-797. That inconsistency could invite closer examination. So make sure everything is aligned and that you possess the documentation to demonstrate it. For L1 visa holders, the same principle applies. Carry your I-797 and your employment verification letter. For F1 students, your Form I-20, issued by your college or university's designated school official, is your status-specific document, and it must be current and properly signed. If you are on optional practical training, commonly known as OPT, your EAD card is equally important to have on your person. For exchange visitors on J1 visas, carry your DS 2019 form. For individuals who have pending applications, whether it is an adjustment of status case or an extension of stay currently under review by USCIS, carry your receipt notices known as I-797C. These receipt notices confirm that USCIS has your application in their system. They do not represent approval, but in an enforcement encounter, they provide meaningful context that demonstrates you are actively participating in the legal immigration process. Now, there is a question we hear frequently that deserves a direct answer. People ask whether all of this applies to them if they are only taking a domestic flight. And the answer in the current environment of 2026 is yes. The rules governing domestic travel have not changed in the sense that flying within the United States does not alter your immigration status. But the airport environment itself has changed. ICE officers are present at airports covering both domestic and international terminals in many locations, and their authority to enforce immigration law is not contingent on whether the flight you are boarding is headed to Miami or Manila. If an ICE officer approaches you at a domestic gate and requests identification, your immigration documents are your strongest protection. And here is a critical practical detail. Carry them in your carry-on bag, not in your checked luggage. If your bag has been checked and something occurs at the gate or at the security checkpoint, you need those documents either on your person or in the bag that remains with you at all times. Let us also discuss what to do if you are approached by an ICE officer. First, remain calm. Do not run. Do not argue. Do not physically resist, even if you believe the encounter is unjust. Maintaining your composure protects you legally and practically. Second, you have the right to remain silent. Under the Fifth Amendment of the United States Constitution, you are not obligated to answer questions about your immigration history, your country of birth, or the circumstances of your entry into the United States. You can politely state that you are choosing to remain silent and that you would like to speak with an attorney. Third, you have the right to request an attorney. If you are detained or moved to a secondary screening area, clearly and calmly state that you wish to speak with a lawyer before signing anything or agreeing to any process. This point about signing cannot be emphasized enough. Do not sign documents at an airport that you do not fully comprehend. A signature given under pressure can sometimes mean relinquishing rights you were not even aware you possessed, or consenting to a process that carries serious long-term consequences. If you feel pressure to sign something, politely but firmly repeat that you want legal counsel present first. Fourth, do not consent to searches of your phone or personal belongings without a warrant. You can clearly state that you do not consent to a search. Officers may still proceed with a search under certain legal circumstances, but your stated objection carries legal significance. Fifth, do not provide false information under any circumstances. Presenting false or expired documents to a DHS officer can lead to removal proceedings or even criminal prosecution. Before you travel anywhere, take a few practical preparatory steps. Speak with your immigration attorney about your specific situation. This is especially important if you have a pending application, an old immigration court case, a prior removal order, or any unresolved matters in your immigration history. An attorney can evaluate your particular risk profile and advise you on whether travel is advisable at this time. Share your travel itinerary, including your flight details, your destination, and your expected return date, with a trusted family member or close friend. If something happens and you are detained, having someone who is aware of your plans can make an enormous difference in getting you legal assistance quickly. Have an emergency contact plan in place. Know the phone number of your immigration attorney from memory or have it saved in a location. that is accessible to someone who can reach out on your behalf. Make photocopies of all your immigration documents and leave one complete set with a trusted person at home. And check the official USCIS website at uscis.gov before you travel, because processing times, form requirements, and policy guidance can and do change. The CBP website at cbp.gov and the ICE website at ice.gov are also authoritative sources for the most current enforcement-related information. There is one more important development you should be aware of, and it concerns employment authorization documents. On December 4, 2025, USCIS shortened certain EAD validity periods to 18 months. This represents a meaningful change from prior practice. If you hold an EAD, check its expiration date right now. If it is set to expire within the coming months, speak with your immigration attorney about filing for renewal as early as possible. The 18-month validity period means renewals will need to happen more frequently than before. And given current USCIS processing timelines, getting an early start on that process is critical. Additionally, as of November 20th, 2025, DHS expanded its biometric entry and exit system to cover all ports of entry, including air, land, and sea. This means that a greater volume of your travel data, including biometric information, is being captured and cross-referenced with immigration records on a broader scale than at any previous point. This further underscores the importance of ensuring your records are clean, consistent, and up to date. Before we close today, we want to remind you of something important. Immigration policy in the United States can shift rapidly. What is accurate as of April 9th, 2026, may look different in the weeks and months ahead. That is why we always encourage you to verify any information you receive, including the information in this video, against official sources such as USCIS, DHS, CBP, and ICE. And for your individual circumstances, please consult with a qualified immigration attorney. Nothing in this video constitutes legal advice. Every immigration case is unique, and the guidance that applies to one person may be entirely different for another. What this video provides is a foundation, a starting point for the conversations you need to have with the professionals who can advise you based on the specifics of your situation. Please remember that being prepared is one of the most empowering things you can do for yourself and your family. Knowing your documents, understanding your rights, and having a plan before you set foot in that airport puts you in a far stronger position than going in uncertain. Immigration enforcement at airports has expanded significantly, and the airport environment of 2026 is fundamentally different from what it was even 12 months ago. But you are not without resources. You are informed, you are prepared, and you have a community, including this channel, standing alongside you. If this video was helpful to you, please take a moment to give it a thumbs up and share it with someone in your life who needs to hear this. Whether it is a family member, a colleague, a neighbor, or a friend who has travel plans coming up, this information could genuinely matter for them. Subscribe to US Updates Hub if you have not already so that you never miss an important update. We are committed to bringing you accurate, balanced, and thoughtful immigration coverage that helps you navigate this complex landscape with confidence. Check the description below this video where we have included links to official resources including the USCIS website, the CBP I-94 portal, and other relevant government pages. Thank you for spending this time with us today. We understand these topics can feel overwhelming, and we want you to know that your safety, your dignity, and your future matter. Keep your documents ready, keep your knowledge current, and take care of yourself and the people around you. We will see you in the next video right here on US Updates Hub. Stay safe, stay informed, and remember that preparation is your greatest protection. This content is for educational and informational purposes only. It does not constitute legal advice.